Okay, good morning. Welcome also from my side. It is a pleasure to welcome you to the first panel of the Cyber Stability Conference 2023. My name is Giacomo Persipaoli. I'm the head of UNIDIR's Security and Technology Program, and I have the pleasure of being the moderator of this first panel. So we will start with a fundamental concept for international law, the use of force. We will try to unpack how this concept translates to the cyberspace and what might be lawful reactions by the injured states. If we had to start, let's start with a difficult concept for our distinguished experts to speak. The prohibition is encapsulated in Article 2, Paragraph 4 of the UN Charter, that reads that all members shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state, or in any other manner inconsistent with the purposes of the United Nations. So, the use of force is already a sensitive and at times controversial issue to discuss even in the physical world, let alone in the cyberspace. So I'm therefore delighted that I'm not alone on the physical and virtual stage today to try to unpack a little bit this complex topic, and I'm very happy to be joined by distinguished experts that I'm going to introduce in a second. I would like to stress that, like for any other panels throughout today's conference, given how little these topics have been discussed in details by states in the context of the official processes, as we've heard during the opening remarks, we see this conference really as a journey of exploration more than as a pursuit of a single truth. It would be an amazing impact story to tell if through a single-day conference, UNIDIR was able to crack the issue of how international law applies to cyberspace. Might be wishful thinking. We're going to try. But every journey has to start somewhere, and we hope that today will serve as an important first step. So I would like now to introduce the panel that is composed of well, 4 people on the panel, 2 joining us in person with me on stage, and 2 online. I just want to check with my colleagues. I hope everyone is connected. I think so, because I saw their name earlier. So very happy to be joined by Professor Vera Rusinova, who is professor and head of School of International Law at National Research University with the Russian Federation. We have Ambassador Maria Leto, who is ambassador and senior expert with the Ministry of Foreign Affairs in Finland. We have Ms. Azucena Sahagun, who is the head of the Multilateral Treaties Department, Office for the Legal Advisor at the Ministry of Foreign Affairs in Mexico. And to my right, we have Mr. Robert Young, who is legal counsel with Global Affairs Canada. So thank you, all of you, for joining us in person or online. Before we start, I just want to give all of you a quick explanation of how you can engage with the conference. We have the Slido platform is available to all of you, whether you are in the room or following us online. Just go to sly.do or slido.com is the same, and enter the code CSC23. And you will then be able to write your questions or see what other questions have been asked by other participants and vote them up if you would like to support them. And we also make the job of the moderator a lot easier if we saw that there are questions that have more interest. If you are in the room, you can either use the Slido platform as well, or if you want to ask the question directly, please press the microphone button. You will see that the microphone light will turn green. That means that you have requested the floor, and then when the time comes for the Q&A, it will be me from here trying to give you the floor. When your microphone is active, it will go red, so that is a signal that you can ask your question directly. If you choose to engage in person, please introduce yourself, try to be brief and to the point so that we can save as much time as we can for the discussion. So the run of show, the first 15-20 minutes of today's panel will be having like an introductory briefing by Professor Rusinova, who is going to give us a little bit of an introduction to the topic. This event is for, I'm assuming most of us, I'm definitely part of that category, are not international law specialists. So we thought that every panel should start with an introductory briefing by an external expert that would at least help us provide a foundational kind of layer of shared understanding of, and knowledge on the topic. And then we will proceed with the presentations from state representatives. So without further ado, I'd like to, first of all, check that Professor Rusinova is connected, that can hear us well, and give you the floor. In the room, there are no speakers, so if you want to hear the presentation and you're not used to UN meeting rooms, please make sure you wear the earpiece, or it will be a very silent room for a while. Professor Rusinova, you have the floor. Thank you.
To check whether I'll be able to run my presentation. And please give a sign whether you can see my presentation or not yet.
Yeah, we can see the presentation.
Okay, thank you. Thank you so much. And dear colleagues, dear Dr. Guys, Dr. Percy Paoli, Your Excellencies, let me first express my gratitude to the organizers for this invitation. I will start with a citation from the Open-Ended Working Group Chair's summary of 2021, which proves, and if you please can show the next slide, which proves that indeed, after having affirmed that international law applies to the use of ICTs, the states are still struggling with the how question, and in particular, how Article 2.4 of the UN Charter and relevant customary law prohibiting to the states to use or threat to use force against any other states applies to the ICTs activities. And this is the topic of my presentation today. Can you please show the next slide, please? So the range of problems surrounding this issue starts from a mere and general possibility to qualify the ICT activities as a use of force. For those answering in positive, and continues with, firstly, a necessity to identify the scope of such activities. Secondly, the problem of the length of the causal nexus between the use of ICTs and harmful effects. And thirdly, it raises the issue of the lawful reactions thereto. So in order to unravel the tangle of these problems, I will proceed in 4 steps. This shows the next slide. I will firstly provide you with the map, sketching where we currently are with the legal discourse. In the second part, I will discuss the content of the difficulties surrounding the endeavors to build up a consensus. In the third part of my presentation, I'll go to the question of the legality of the reactions of the injured states. And finally, I will conclude by discussing the possible ways to find a compromise in this sphere. Can you please show the next slide? So I'll firstly map the legal discourse on how Article 2.4 of the UN Charter should apply to the ICT context. So the qualification of this question took place in the managerial forum by experts and scholars in a more or less deductive manner, and also in the form of the state consent-based format. So for obvious reasons, the expert and academic community was quicker with the results. Next slide, please. And alongside with many scholarly articles and monographs, and just to name a few of them, I can definitely make reference to the monographs of Marco Rancini or François Delvaux, which represent the so-called academic managerialism. We have also got 2 editions of the Talon Manual, and it was adopted by governmental experts under the auspices of NATO. So therefore, this writing cannot be or can hardly be qualified as a product of independent scientific expertise. However, what is remarkable with respect to the Talon Manual that even the members of this group, the experts, were not on majority of issues, details, subtopics concerning the application of Article 2.4 of the UN Charter to the ICTs, they were not able to come to the compromise. So behind the black letter rules, in majority of cases, we cannot find a compromise position of these experts. States. States were and continue to be seized with the question of how international norms should be applicable with respect to ICTs in many different formats. They are collective, like the previously GDE or currently the open-ended working group. And states have also started to express their opinion at the national level and share these opinions internationally. This is relatively a new trend. So managerialism is slowly giving way to a state consent-based forms. Discussing the application of Article 2.4 to the ICTs in order to bring normative results, states' behavior should be able to form either a new ICT-specific customary or treaty law or constitute a subsequent practice of states influencing the interpretation of existing treaty and customary rules. In our case, Article 2.4 of the UN Charter. However, the problem here is both of the qualitative and quantitative character. So let us consider first the creation of customary rules. As everybody knows, the formation of a custom requires two elements. Firstly, general state practice, and secondly, opinion juris. The practice of states is rather scarce here. So setting aside the issue of official attribution, what is crucial is that at the current moment, no state has officially qualified any harmful ICT act as a breach of Article 2.4 of the UN Charter. In interstate relations, states suffering from different cyber acts tend not to use the language of international law, even in situations which could have been hypothetically qualified as a breach of these rules. States employ either political rhetoric, calling them cyber war, cyber attacks, or by mentioning international law in very, very general terms, like, for instance, I cite a flagrant disregard of international law. Two examples, however, can be regarded as exceptions to this pattern. One state has designated the case of harmful use of ICTs in 2019 as infringing on its sovereignty. And another state declared computer incidents of 2021 as violating the principle of respect for the territorial integrity. Moreover, the problem with the second element of customary law, opinion juris, lies in the lack of uniformity. Positions of states concerning the qualification of ICT's activities under Article 2.4 of the UN Charter look like a patchwork and are very far from any consensus. The application of another option, which is to qualify subsequent states' behavior as an authentic means of interpretation, which can adjust application of Article 2.4 of the UN Charter to the ICT context, is also hampered. Although such practice can touch not all states, according to international law, it should be a common understanding regarding the interpretation of a treaty which the parties are aware of or which they accept. As we know, 15 states express their positions, their official national positions, in the compendium published by the Open-Ended Working Group. 9 states, members of the Organization of American States, gave their responses to the questionnaire. And there are a dozen of the official positions of states expressed at the national level. But this is still not enough for the requirement of the quantity. Moreover, the content of the state's positions, as I have already mentioned, significantly vary. In addition, should we speak about a standard-setting track consisting in the elaboration of norms, rules, and principles of responsible states' behavior, this track escapes the issue of such qualification. It is primarily focused on precaution and capacity building. Next slide, please. So I will turn to the problems surrounding the endeavors of states to build up a consensus. And the first problem can be called to be an ontological one. It should be admitted that it was the military paradigm to treat computer incidents that received the bulk of attention. Its first indication was the choice of terminology for the designation of malicious computer acts as operations, attacks, or even warfare. But according to the behaviorists, framing plays a crucial role in the perception of problems. We have to admit that harmful use of ICTs may cause significant damage to a state, which some interpret as a reason for a military component in the ICTs. But the question is, How far can we go? As lawyers, I think we should be aware of possible distortions and withstand the pressure. However, as a result of the preoccupation with the military paradigm, the other perspectives, the sovereignty and law enforcement perspectives remained on the sidelines, albeit taking into account both the rise of non-state actors in the use of ICTs and all known difficulties with the attribution of such malicious activity in the use of ICTs to states, this distortion is really unjustified. The second problem and another issue here is that the commonly used logic of the application of jus ad bellum to the use of ICTs is based on the acknowledgement that the prohibition of the use of force may be violated by any use of force, regardless of the type of weapon, and it is underpinned by the permissibility of the analogy with kinetic attacks. Under this approach, anything causing death, injury, or destruction of physical objects fall under the scope of Article 2.4 of the UN Charter. This analogy is applied notwithstanding the fact that the chain of consequences launched by the use of ICTs might be, and usually is, significantly longer in comparison to the conventional or so-called conventional use of force. So not challenging the fact that some operations with the use of ICTs can be used for military purposes, the use of analogy can be overstretched to produce results contrasting with the well-known refusals of the drafters of the UN Charter to understand economic coercion, which can also lead to many deaths, as falling under the scope of behavior prohibited by Article 2.4. Nonetheless, during the open-ended working group meeting held in 2020, many states, by using the analogy, affirmed the applicability of the jus ad bellum norms of international law to harmful ICT activities. At the same time, some states expressed their concerns and doubts. They have either underscored the lack of clarity in respect of the threshold, the minimal threshold of the use of force, and the distinction between the use of force and armed attack, or in general stress their concerns about the applicability of Article 2.4 and Article 51 as well to computer attacks. One state took the most stringent position that a computer attack occurring outside the context of an armed conflict cannot fall under the scope of these provisions. Should we take the official compendium of voluntary national contributions of 2021, there are only 11 states which explicitly confirm the applicability of Article 2.4 on the basis of an analogy with kinetic attacks. It is noteworthy that one of them particularly stressed that such a qualification can be employed only in extremis. Now I turn to the third problem, and this is a reference to the scales and effects approach. So it is a commonplace for states, while admitting the possibility that the use of ICTs can fall under Article 2.4 of the UN Charter, to make reference to the scales and effects approach, with a reference, and let me cite position of one state here, that the elements of such an analysis are well established in the ICJ's, International Court of Justice, relevant jurisprudence. However, we should be careful and not read too much into the ICJ's position. With respect to the minimal threshold of Article 2.4 of the UN Charter, the court was rather laconic, acknowledging in paragraph 228 of the military and paramilitary activities judgment that the cases of the use of force should be distinguished from intervention into domestic affairs. The scale and effects approach has been applied in this and also in oil platforms case for the distinction between the use of force on the one hand and armed attacks on the other. The court observed that it is necessary to distinguish the most grave forms of the use of force, those constituting an armed attack, from other less grave forms. The articulation of this general approach is far from giving any clarity with respect to the placement of a minimal threshold for the application of Article 2.4 of the UN Charter in general, not speaking about the ICT context. The fourth problem, in my opinion, is the extension of the scope of Article 2.4 even beyond the analogy with kinetic attacks. So even if you will not doubt the soundness of the approach based on analogy, the majority of the publicly known computer incidents do not reach the threshold of the use of force just because of their low intensity. It probably explains the desire of some states to extend the scope of the internationally prohibited use of force. So, for instance, one state that set forth that an operation with the use of ICTs without physical effects may also be qualified as the use of force and suggested using a not exhaustive list of criteria. Two other states articulated that an operation with the use of ICTs with a very serious financial and economic impact, for instance, a sustained attack against the banking system, may qualify as the use of force. So it seems that these approaches do not reflect the existing international consensus regarding the scope of application of Article 2.4 of the UN Charter. Next slide, please. Now let me switch to the question of legality of the reactions of affected states. And in practice, responses by the states suffered from the harmful use of ICTs include unilateral coercive measures, the expulsion of diplomats, criminal indictments under domestic law, and very rarely taking back. According to our calculations, unilateral coercive measures have been applied in response to 13 cases of the use of ICTs so far. So states must respond to malicious use of ICTs against them, including computer acts, in accordance with international law. And any measures by itself breaching international law can be applied only in the form of countermeasures under the law of state responsibility. But the challenge of application of these norms lies in the necessity to attribute malicious computer acts committed by individuals, groups of individuals to a particular state, which also goes in conjunction with another problem, which is a duty to reach any of the standards of proof applicable in international law. Moreover, use of countermeasures requires prior notification. Moreover, the problem is also that the use of the military paradigm of the legal qualification of harmful ICTs activities as a use of force, so to say, fires back and significantly limits the possibility to resort to countermeasures for the states. So according to the customary law applicable to countermeasures, one of the requirements of their lawfulness is that they shall not affect the obligation to refrain from the threat or use of force, as embodied in the UN Charter. Hence, a mirroring ICT response to a computer attack might be unlawful. Well, it is a very rare case that states publicly confess of having used ICT means in response. However, in 2018, the president of one of the states, for the first time, and of course post factum, publicly confirmed that such covert cyber attack took place. Needless to add that in this case, neither the initial ICT activity nor the response thereto even hypothetically reached the level of the use of force. Next slide, please. So speaking about possible ways to find a compromise, I think we should have as a starting point the tenet that international law in the sphere of the use of force is universal by its nature. Thus, it can be added, adjusted, or interpreted only by universal action. However, at the current moment, I think not all possibilities to find a compromise have been exhausted. We must definitely positively welcome that states have started to share their views on the application of the UN Charter in the ICT activities. But I think that if the sessions or briefings where the states exchange their views turn to the sessions aimed at finding a common consensus, this will definitely move the whole question from a deadlock towards legal certainty, stability, and finally contribute to international peace and security. These endeavors will have a prospect for success if they are underpinned by such general principles as universality, inclusiveness, transparency, deliberation, and expertise. And speaking about deliberation and expertise, the mandate could have been given to highly qualified legal professionals. So thinking about possible formats, one option could be to entrust with such a mandate the Sixth Legal Committee of the UN General Assembly. States can also consider another option and use for these purposes the format of the open-ended working group and think about the creation of a expert legal group in its framework. So coming to my conclusion, as a scholar and personally, I'm convinced that we are indeed facing one of the crucial moments in the history of humanity, when even in the face of our ever-growing dependence on the ICTs, we are still able to make choice, to choose, and to set up a paradigm based on the de-escalation and peace. It will require the states to focus their endeavors on precaution and peaceful settlement of possible conflicts, which will guarantee that, hypothetically, an act of hacking will not end up as a war. So it is in our hands. It's our responsibility. So let us give a chance to a peaceful paradigm. With having said this, I thank you very much for your kind attention.
Thank you, Professor Rusinova, for this presentation. It was very useful, and thank you also for not only introducing us to the topic, but also going the extra mile and trying to chart a potential pathway ahead. I have some questions, but in the interest of time, I think I'm just going to keep them for the end of the session. And now would like to enter the second part, which is the next. I would say 25 to 30 minutes, we're going to be hearing a series of national perspectives, general perspectives on the applicability of this specific article of the UN Charter to cyberspace. And then we will follow up with some more targeted questions. But I would like to give the floor now to Ambassador Leto and give you the chance to, sharing with the audience here in New York and online your perspectives on this interesting topic. Ambassador, over to you. You have the floor.
I hope you can hear me.
Yes, we can.
Very good. Thank you, Mr. Chair. And I would also like to thank UNIDIR for organizing this timely conference and for the kind invitation addressed to me. And similarly, I wish to thank Professor Rusinova for her interesting briefing. Finland issued its position paper, national position paper on international law and cyberspace in 2020. This paper addresses a number of topical questions that had been raised in the context of the CTE from 2010 to 2017, or in other national statements or position papers after that. Commenting on the question of the use of force, I will draw on that paper and also on an earlier MFA publication from 2015 on the legal grounds for the use of force, which includes a chapter on the use of force in cyberspace. I will concentrate on Article 2, Paragraph 4, and mention Article 51 only where necessary. As I understand that, there will be another panel to discuss the question of self-defense in cyberspace. And I believe that I can summarize Finland's views quite succinctly so that we also have time for questions. Let me at the outset state that Finland attaches a lot of importance to the general prohibition of the use of force in Article 2, Paragraph 4, as a cornerstone of the UN Charter's legal regime. This entails, for instance, that the distinction between armed attack as a particularly serious violation of the Charter on the one hand, and any lesser use of force on the other is preserved, and that the right of self-defense as an exception to the general security system of the Charter is interpreted restrictively. On this basis, we would also underline that any understanding of the use of force in cyberspace should respect the UN Charter, not just the letter of the Charter, but also its object and purpose, which is to minimize unilateral use of force. Like most, if not all, of the states that have pronounced on the issue of the use of force in cyber context, Finland agrees that for a cyber attack to be comparable to the use of force, it must be sufficiently serious and have effects in the territory of a target state or in areas within its jurisdiction that are similar to those of the use of traditional armed force. This would mean, in the first place, physical damage to property and or loss of life or injury to persons. The applicability of Article 2.4 of the UN Charter to cyber activities, in our view, does get important support from the advisory opinion of the International Court of Justice on the legality of the threat or use of nuclear weapons, in which the court held that the prohibition of the use of force does not depend on the type of the weapon used. We also agree that applying Article 2.4 to cyber activities will require some adjustment. In this regard, I would also like to comment on a few issues that still remain unsettled. One example is the question whether cyber operations resulting in the loss of the functionality of the cyber system can amount to use of force. What I would say is that if the loss of functionality is serious enough to incapacitate critical infrastructure, leading to a disruption of essential services, it would seem possible that it may be equated to the use of force. Such an attack affecting or targeting, for instance, public health or food or water security would seem likely to result in the loss of life or injury or damage to property that is comparable to the damage caused by traditional weapons. Another frequently raised example concerns the situation, and I think Professor Rusinova also mentioned this, a situation in which a cyber attack would produce significant economic effects, such as the collapse of a state's financial system or parts of its economy. Should such a cyber attack be equated to an armed attack? This is the question. The Finnish position paper only says that this question merits further consideration. But I would add that such a collapse would be likely to cause serious effects in the target state, including on the population. Both examples would require that the indirect effects of the attack are taken into account. In a sense, the havoc that may be caused by a cyber attack is always an indirect effect of the original wrongful act that may consist of deletion, alteration, or corruption of data. At the same time, indirect does not necessarily have to mean long-term. Great care is nevertheless required when considering such new interpretations of Article 2.4. In any event, including the two situations within the concept of the use of force would require that the effects of the cyber attack can be assessed with sufficient precision. We should also take into account, and this too is something that was already mentioned by Professor Rusinova, we should take into account that luckily there is no state practice of cyber attacks that would have been characterized as use of force, and therefore limits to how far we can go in defining such attacks in abstracto. Any cyber attack that could be characterized as use of force would therefore have to be subject to a case-by-case assessment. Let me add that the prohibition of the threat of force is similarly applicable in cyberspace, provided that the threat is sufficiently precise and directed against another state. This is an issue that has so far not attracted much attention, but the question was raised recently whether a cyber operation that may not affect the functionality of the system as such whether it could be seen as a threat to the use of force if it precedes a more serious cyber attack as a preliminary stage closely linked to the later operation. I think this is an interesting opening, but believe that there should be a clear link between the two operations so that the first one could be understood as communicating a threat. Much discussion is still needed on this a bit ignored issue. My final point is a general one. It concerns the need to pay due regard to the broader legal context. Particular issues concerning the use of force may need cyber-specific solutions, but these should always be assessed in light of the more general understandings. It should also be kept in mind that many of the issues related to the use of force continue to be debated, even in the physical or kinetic context. The International Law Association's Committee on the Use of Force, in its 2018 report, captured well this point in stating that any conclusion concerning cyber operations as a use of force must be reached with great caution. And this because a wide interpretation of Articles 2.4 and 51 of the Charter in cyber context, I quote, may affect the interpretation and debate surrounding other areas of the law of the use of force, unquote. It's hardly desirable to define the use of force in cyberspace in terms that essentially differ from the rules restricting the use of armed force, or lead to interpretations that could enter into conflict with the fundamental purpose of the Charter provisions on the use of force. Mr. Chair, it's back to you. I thank everybody for your kind attention.
Thank you, Ambassador Leto, for your remarks. I took notes. I also have some follow-up questions, but we'll dig into the details in the after this first round of initial introductions. But thank you so much for sharing your views with us. And I would like to give the floor to Ms. Sahugun on my left. Please, you have the floor.
Thank you. Thank you very much for giving me the floor. Allow me first to express my gratitude and recognition to UNIDIR for organizing such a relevant discussions. I am very honored also for being invited as a panelist, and I would also like to thank everyone who helped bringing us all together today. Concerning the national position of Mexico on the provision of the use of force in the context of ICT domain, we are glad that the affirmation of the international law is applicable to cyberspace has become practically universal, encompassing the views not only of governments, but also civil society, academia, the private sector, and the technical community. For Mexico, references to international law comprises not only the UN Charter, but also international human rights and international humanitarian law. In this regard, we strongly support the reports of the Open-Ended Working Group and the group of governmental experts on advancing responsible state behavior in cyberspace. These reports actually reflect the collective efforts of international community to deepen the discussions of the responsible use of cyberspace in order to promote peace and security. Historically, we have witnessed diverse improvements in the conduction of hostilities in armed conflict. As a matter of fact, wars have always taken advantage of technologies demonstrating the capacities and powers of the combatants. Therefore, we also agree with the advisory opinion of the ICJ, which was already referred by Ambassador Leto, that principles and rules of international humanitarian law are applicable in armed conflict to all forms of warfare and to all kinds of weapons, including those of the future, which are actually the ICTs. However, the law of armed conflict was conceived for a specific model of armed violence where the damages and effects are tangible. That is one of the main reasons that led to the discussions for the last decades on the ways in which international community should address the use of TICs and cyberspace in the context of armed conflict. The nature of cyber operations and the use of TICs and ICTs, and the level of precision and military advantage they represent in an armed conflict, mainly for the destructive potential and the multiplication of challenges of states in these regards are, as Ambassador later also said, the cornerstone in the pursuit of international peace and security. Moreover, technological dependence, which is more evident since the COVID-19, requires solid legal frameworks aiming to favor the responsible behavior of states in cyberspace while protecting not only persons but also the civilian infrastructure. That is why we also share the general vision of other countries and organizations which promote the application of international humanitarian law in the context of cyberspace. Besides, Mexico favors to further the analysis on how the ICTs are conducted and used in cyber operations, but also considering its impact and effects, since the contexts, the subjects involved, and the consequences are not the same. Mostly, the subjectivities of these elements has made it difficult for international community to actually reach a common understanding, as actually Professor Vera Rusinova already mentioned. In addition, my country coincides with the IRCC that the recognition of the applicability of international humanitarian law to the use of TICs must not be construed as legitimizing or authorizing any act of aggression, but shall be interpreted as a means to avoid the human suffering in situations of armed conflict. The use of force implies per se an act of violence which may have different scope and therefore shall be addressed considering the principles of international humanitarian law, such as distinction, proportionality, precaution, and necessity. In these cases, it is important to assess if the use of force is expected to cause death, injury, or damage, even if the damage is not physical and cannot or is non-tangible. Then, it would be essential to question, at least, if this behavior is prohibited in international law. Was it done in legitimate or in self-defense? And can we attribute those conducts to a certain state or not? Finally, we will also like to remark that from the Mexicans' perspective, there's been a kind of abuse of the use of the legitimate defense lately. Actually, we have asked the Committee of the Charter of the United Nations to initiate a discussion on the abuse of invoking the legitimate defense. And also, following what Professor Vera Rusinova just mentioned, back in 2020, when participating at the GGE, we proposed that the Sixth Commission, particularly the International Law Commission, started an analysis or an evaluation to find out if it is necessary to establish a legally binding instrument concerning specifically the use of force. That would be it. Thank you very much.
Thank you. Thank you, Ms. Sagun, for your presentation and sharing with us your thoughts on international law from a Mexican perspective. I now give the floor to Mr. Young here on my right.
Bonjour, merci beaucoup. Thank you so much. Good morning and good afternoon or good evening to those joining with us virtually from different time zones around the globe. And for some of you, thanks for staying up late to be with us. I want to start by thanking UNIDIR for inviting me to share Canada's views today. And let me just express my appreciation and congratulations to UNIDIR for focusing on international law at this year's Cyber Stability Conference. This is a subject of great importance for Canada, and I would say for our open-ended working group. It's a timely topic given the state of our world today, and especially timely, as was mentioned in the first panel, as next week, for the first time, the OEWG will launch focused discussions on selected international law topics in accordance with the consensus report we agreed last summer. And I think it's well chosen that we'll start the discussions next week at the OEWG with the Charter, and well chosen as well that the Charter is the focus of today's conference. I would say as well that the choice by UNIDIR to focus on the Charter today is, I think, to be commended as well for advancing the explicit and very specific commitment of member states at the OEWG to work on capacity building on international law as it relates to cyberspace. I think today's conference gives us a real opportunity to listen, exchange, and to learn together, and that's what capacity building is. And I think it will help us move towards the goal of common understandings, to use OEWG language, and then onward to consensus, and ultimately to greater stability. I'm going to briefly set out Canada's position on the use of force in cyberspace and mention some views of other states and commentators, but a few preliminary remarks before I do. These may seem fundamental or basic, but I think they're important for context. Canada believes in the rules-based international order and believes that this is rooted in international law and that our collective security depends on both of these. It was thus our point de départ, going back some years, that the rules-based international order and international law do and should extend to the growing field of state activities in what we now call cyberspace. I say point de départ, or starting point, because this was really a working assumption that Canada saw as important to assess or test and validate. And I can tell you that this view was affirmed by Canada through the process of developing our national statement, which was published in April last year. The process of analyzing systematically many aspects of international law in relation to cyberspace, it affirmed our view that existing international law, complemented by the 11 UNGGE norms, provide a very solid and sufficient and workable framework for responsible state behavior. Today, in 2023, we don't need to develop new rules for cyberspace. We need to, together, as a community of member states with shared interest, determine how established, accepted, well-known rules of international law apply to these growing new activities. So I'll turn now to the use of force. As has been mentioned, Article 2.4 is the starting place for that. And for Canada, it's very clear that this prohibition, this widely accepted, really fundamental prohibition, applies in cyberspace. We note that the final 2021 UNGGE report affirmed this at paragraph 71D, amongst others, and as well as was agreed in the first OEWG report. This conclusion, I think, enjoys very broad consensus amongst member states and has been further and helpfully clarified by quite a number of states that have publicized their views, their national statements. I would note that this is also consistent with Rule 68 of Talon Manual 2.0, which many in the room will know that this is an important reference in this field, reflecting the considered views of a range of international law experts. Now, Canada didn't elaborate extensively in our national statement on the rule on the prohibition of the threat or use of force, I think mainly because we view this as quite straightforward and perhaps even self-evident, in our minds at least. One point we didn't include, but I think I wish we had, and it's been referred to today by our colleagues from Mexico and from Finland, was the ICJ holding in the Nuclear Weapons Advisory Opinion that the UN Charter does not limit itself to specific weapons or other means of the use of force. And that, I think, was by design at the time and has proven to be a wise approach by the drafters of the UN Charter. They couldn't have foreseen in the 1940s the technologies that we're using today. Think about this. My late father, who grew up in rural Western Canada, recounted to us as we were growing up that in his world, an invitation on Saturday night that his family looked forward to was to go to a neighbor's house, neighbors who owned a radio that would be put in a bowl on the table so they could to amplify it, and a group of several families would sit around and listen to a radio broadcast. That's one generation. And that was a big night out from our father. So he may have said he lived a simple life, but one generation ago. And so to expect that the drafters of the Charter could have anticipated the developments of technology that allow us to gather virtually around the world on every single continent at the same time, I think would be expecting too much of the drafters of the Charter, who I think we'd all agree did some pretty historic and important work. And so the fact that the Charter doesn't limit what the use of force or the threat of use of force might mean leaves it to us to then apply those rules in our contemporary setting. So then how do we assess, how do we understand threats or use of force? Well, for Canada, we generally evaluate whether cyber activities rise to the threshold of a threat or use of force depending on the scale and effects of cyber activities on a case-by-case basis when compared to other, typically kinetic operations, that are accepted to be uses of force at international law. Our statement is very clear, our view is very clear, that it will have to be done on a case-by-case basis, but then again, what isn't done on a case-by-case basis in international law? But it needs to be, because this is an area where we are being faced with new situations and we need to apply well-established rules carefully. Canada's approach, using a scale and effects test, is consistent, I'd mentioned, with the views of many states that have already pronounced on this, and of course with Rule 69 of Talon Manual, if you want to look there. Canada, I think, particularly like, for example, Poland, in its most recent statement in 2022, said, "What matters are the effects of a taken action." We appreciate the clarity and succinctness of the Polish position. And we similarly find very helpful the Finnish approach, which was outlined by Ambassador Leto. So then what factors should we look at in assessing scale and effects? Well, Canada, I can tell you, benefited greatly in developing our statement in reviewing the published statements of states that had already come before us, and we continue to study the states that come out. For example, we appreciate Norway's view from 2021 that scaled effects should be evaluated on a case-by-case basis and using a number of non-exhaustive factors. Those include immediacy, directness, and measurability. And those are three that Canada thinks it would be useful that we consider further together to examine to understand what those would mean in cyberspace. We note that Romania, France, and the US seem to share a broadly similar set of relevant factors, and we think those all merit consideration. And we also think that what merits, I think, consideration is that most of the lists of factors that have been set out by states are non-exhaustive, and we think that this is probably the right approach. We'd encourage other states to consider the scale effects test as the appropriate one, and when evaluating whether an activity may rise to the threshold of a threat or use of force. And we'd encourage other states to publicize their understanding of the factors and how this test would work. On potential uses of force in cyberspace, in our statement, we didn't provide examples of what we would consider a threat or use of force. Perhaps we would if we were publishing it today in 2023 with the benefit of greater understanding and greater publications that we find very useful. But we'd encourage other states that are considering developing national statements to propose examples in their own public statements. We appreciate Netherlands' view from its 2019 statement that while armed force that has a real or potential physical impact is prohibited, they said in 2019 that it cannot be ruled out that a cyber operation with very serious financial or economic impact may qualify as the use of force. And similarly, we appreciated Italy's view from 2021 that mere loss of functionality without material damage may constitute a use of force, as cyber activities that may interrupt the delivery of essential services without necessarily causing physical damage. A cyber operation that severely damages or disables a state's critical infrastructure or functions may even rise to the level of an armed attack under international law. I'll leave that to the next panel, along with questions about the application, what triggers the application of IHL, which is certainly an important consideration for Canada. Just a few words on threats, maybe. We didn't, in our statement, define explicitly what we would consider a threat in cyberspace, and so we're interested to hear the views of others. But we appreciate that Finland, in its statement, said that threats must be sufficiently precise. And we appreciate as well that Japan, in its 2021 statement, said that a threat would include a state's intention or attitude of using force without actually using force, unless its arguments or demands are accepted, with the emphasis on the coercive effect of a threat. I'd be remiss not to mention the importance of the obligations concerning the Pacific settlements of disputes, obligations on all member states. This will be discussed later today, but I would simply say that when there are cases that may amount to a threat or use of force, states should definitely remember those obligations to settle disputes by peaceful means. Nor will I go into detail to the extensive law on countermeasures, but I will mention one point there, that countermeasures, we all know, cannot be taken in retaliation and must not constitute the threat or use of force. Just before finishing, I wanted to mention, again, that Canada looks forward to seeing more national statements from other states. We think this will be key in developing the consensus in our Open Ed Working Group and more broadly, providing guidance for states. Canada has benefited from developing our statement and continues to benefit from the contributions of a wide range of non-state actors, and I won't be exhaustive, but I would mention the Talon Manual, the Oxford Process, the work of Chatham House, the CCDOE COE Legal Toolkit, permanent observers such as the ICRC, whose work has been so important in relation to IHL, and of course UNIDIR's own work. Your own research and publications, the portal and so on, are a valuable and credible source of information for member states that we would certainly commend for other states who are looking at this. These are all good sources. But in the end, it is states, not those other actors which make international law. And the onus is upon us, as the chair has said this morning, to continue to work together constructively to start to build greater common understandings. In conclusion, it's clear to Canada, and we hope to all, that the UN Charter prohibition on the threat or use of force clearly applies in cyberspace. States must be vigilant in respecting their obligations in this regard. Canada supports the call for more states to develop and publish their views, and we'd be happy to share our own experiences in developing a national statement to assist officials from other states developing your national positions. So feel free to be in touch with me or other colleagues from Canada. I'll stop here, Chair, thanking colleagues who are with us and those who are with us virtually for your time and interest. Thank you.
Thank you very much, Mr. Young, for sharing Canada's perspective on this topic, and also for setting UNIDIR among the list of organizations that are doing useful work in this regard. So we have about 20-25 minutes now, and I have a very long and rich list of questions that have come from the audience on our online platform, and I'll go to those in a second. But I wanted to start this more kind of Q&A part of the event by asking some of you some follow-up questions, if possible. And I'd like to start with Ambassador Leto. And a question for you is really, about lawful responses to acts of, or acts of use of force or use of force that do not reach the threshold of armed attack. So what could be some lawful responses in that scenario?
Thank you very much for this interesting question. I would begin by a general point, referring to what I said earlier about the need to pay due regard to the broader legal context and the fact that many of the issues related to the use of force continue to be debated even in the physical context. For example, and this responds to your question, Mr. Chair, there is an ongoing debate regarding the lawful responses to the acts of armed force that do not reach the threshold of the armed attack. This question has been debated for quite some time. One of the most powerful interventions was made by Judge Zima in his separate opinion to the oil platforms case in 2003. In this opinion, he held that it would be reasonable to conclude that the victim of the use of force falling below the threshold of an armed attack would have the right to resort to proportionate defensive measures of a military nature, using force, but not, but only in a limited manner. While there has been some support for this view, for the view that the target state could take some limited forcible action, I am not aware of any widely shared agreement to this effect. And certainly, this is not an issue that should be settled in the cyber context only. The question is not specific to cyber activities, even though it is relevant to them because of the proliferation of hostile cyber attacks. And obviously, we should also keep in mind the overall purpose of the Charter, to contain forcible action. Regarding the measures, let me mention the question of the availability of collective countermeasures. I believe many of us agree that in any event, the state that has been target of the use of force may resort to countermeasures, peaceful countermeasures as defined, for instance, in the International Law Commission's articles on state responsibility. But the issue of collective countermeasures has been recently raised in this context, the context of cyber use of force. In general, Finland views favorably the possibility of joining forces, in particular as a reaction to violations of peremptory norms of general international law, jus cogens. But we do not think that this issue should be considered as specific to cyber activities. Particular issues concerning the use of force in cyberspace may need cyber-specific solutions, but as I said earlier, these should always be assessed in the light of the more general understandings. This is what I would say to this question. Thank you.
Thank you. We may come back to this question also to hear the perspective from other speakers, but in the interest of time, I'm going to try to add a little bit more questions to the table here. And this is one that I had in my notes, but it's also related to something that was asked by someone in the audience, and really reflects to the relationship that exists between the prohibition of the use of force and non-state actors. So how does that prohibition of the use of force relate to the acts of non-state actors? And I would like to turn to Mr. Young, if you don't mind taking this one.
Thanks so much for that. I think my answer for Canada here would be threefold, as I've been thinking about it. First, Canada applies the customary international law on state responsibility as it relates to attribution. So this law on state responsibility, I think, is well known to this audience. It, of course, covers situations where a state can be held responsible at law for a non-state actor's activities, in this case for the use of force. And this would be the case, as we know, where the non-state actor acts on a state's instruction or under its direction or control. In such a case, the non-state actors' actions are attributed to a state. States can't escape legal responsibility for a non-state actor's use of force when there is this necessary nexus of direction or control. So there's no contracting out of UN Charter obligations in cyberspace, I think, is where we look at it firstly. Secondly, in this case, when we want to talk about non-state actors, we'd also look to the UNGGE norms. Several of these are relevant and have to do with states not allowing their territories to be used for acts contrary to the rights of other states. And for Canada, these are not necessarily obligations, but expectations. A state with knowledge of malicious cyber activity coming from its territory is expected to take all appropriate and reasonably feasible steps to stop this. And then thirdly, on due diligence, Canada is not convinced that there is a general customary international law rule here of due diligence, but we do continue to study it. And as I mentioned, in the meantime, I think the voluntary norms carry us a long way in responding to non-state actors.
Thank you. And I want to turn to you and ask really, Ms. Ahoon, ask you about a question that really reflects on the lower intensity cyber operations. So we've heard a lot about the approach on scales and effects, and how the kind of the equivalence or the ability to draw parallels between scale and effects of cyber operations versus kinetic effects. So the question that I have for you is, could a number of lower intensity cyber operations that would fall, taken individually, below the threshold of use of force, could they cumulatively be considered as use of force?
Thank you. This is a discussion that we have recently had internally in Mexico. We put an example just to make this assessment more interesting. Let's say, for example, that state A does not allow state B access to a certain infrastructure that allows internet to get in the territory. So this implies consequences in the health and the educational systems of state B. Then, again, state A does block or conducts the negation of services in state B. And this is constantly happening. What will we do in that situation? Well, first we will have to address the scale of the consequences of these actions, not only in the infrastructure per se, but also if there is a significant economic or other type of impact. And then also considering if the loss of functionality is causing other damages. Then we will have to evaluate if state B would be legitimated to act, and if those actions will be considered self-defense or not. Because there is actually not violence at all, but the consequences may have specific effects on the civil population. So that is what we have been discussing, and yet we have not arrived to a very formal conclusion, but it's something that we are considering on a daily basis. Thank you.
Thank you. I have an interesting question that is coming from the audience. I'm just going to ask it to the entire panel, and please, Vera, if you're still online and want to chip in, very happy for you also to share your perspective on this. The question reads, it is difficult to define when a cyber attack crosses the line of Article 2.4. And you also mentioned, Robert, in your presentation about some of the factors that could be concluded. The question is, could a list of criteria, I guess, editorial control on the question of shared and internationally agreed criteria help in this regard? Anyone that would like to have a go at this question from the audience? Please.
I'm going to agree that absolutely yes, a list of criteria is really useful. I think, as I mentioned, it's ultimately going to be a non-exhaustive list of criteria because we, like the UN Charter's drafters, we can't imagine the future entirely. But I think it wouldn't be too hard to come up with pretty broad consensus on a non-exhaustive list of criteria. And I know some of the academic work has been analyzing what states have proposed so far. And I think there's a significant convergence already there. And we should study that further in the OEWG and in other fora.
Thank you. I don't know if Ambassador Leto or Mr. Gun, if you want to add anything on this?
Just to add on what Robert has already said, this also goes hand to hand with the subjectivity of the interpretation. So it's a challenge, but also at the same time it guides countries. And just to take it like that, like a guidance, because at the end you will have to go back even to your own national legislation, because sometimes you cannot consider everything under international humanitarian law or other international rules, but also in the prosecution laws, internal prosecution laws. Thank you.
Thank you. Ambassador Leto, I believe I see your virtual hand up, but there might be a glitch in the system. I don't know. If you want to intervene, go ahead.
Enough. Yes. Very briefly, I just wanted to mention that there is a list contained in the Tallinn manual called after Professor Michael Smith as the Smith criteria, which is quite useful. It refers to immediacy, directness, severity, and other such factors. But the Tallinn manual also underlines that there are no criteria, no strict criteria, but useful factors that may help in a situation to assess whether a cyber attack could amount to a use of force. And I fully agree with the previous speakers in that this should be a situation of a case-by-case assessment. Thank you.
Thank you. I think we have time for one last round of questions, and it's something that I had also in my notes, particularly for you, Ms. Agun, but since it also came from the audience, I'm just going to open also to other panelists if they're willing to share their views on this. Could or why shouldn't loss of functionality without physical effects be considered use of force? So this is, we heard some states have already come forward publicly on their views on this, but just wanted to get your opinion.
Thank you. I am going to quote you. At the beginning of this session, you were saying about, you were talking about the single truth. So I believe this is just an example of that. The loss of functionality can be not seen as a single truth. So we don't know the scale or the impact of that loss of functionality and what other consequences it may have. So this is why we have to evaluate it also on a case-by-case analysis, and then coming to a conclusion, because otherwise it's going to be chaotic, even internally, more in the international context, to decide if all loss of functionality could be considered use of force or not. Thank you.
Thank you. Mr. Yang, you would like to take on this? No? Okay, then for you, I may come back to the first question that I asked Ambassador Leto, and if you wanted to share with us what would be your perspective on lawful responses, if you don't mind.
Yes, thank you so much. I think I'm going to take the safe approach of saying I agree entirely with Ambassador Leto, whose prowess in international law is well known to many here. But I think just to remind the audience of what some of the elements might be, I think the question, let me just check, is the one about responses, isn't it?
Correct.
Yeah,
yes.
okay. So my answer here for Canada would be threefold. First, retortion. That's anything that is retortion is by definition lawful. So all of the tools available under the heading of retortion, if you like, in the pre-cyber era, are equally open to states to use as part of their lawful responses. And retortion, the tools in the retortion toolkit are, if you like, time-honored tools that allow states to signal to other states what's acceptable and what's not acceptable to them. It covers, I suppose, the sometimes what can be unlawful, but also what is sometimes called lawful but awful. And so retortion is available for all of those. Secondly, of course, countermeasures, as has been mentioned. I think there's no question that the law on countermeasures would be applicable in cyberspace as it is elsewhere, and so that's an important area. And I think the third that has to be mentioned is, again, can't be said enough, all the obligations and tools regarding the peaceful settlements of disputes. I think states should look to those when confronted with a possible threat or use of force.
Thank you. I see Professor Rusinova has her hand up, so please, you have the floor.
Thank you so much. So, Mr. Chair, if you allow me, I'll address two questions concerning, first one concerning the lawful responses, and the second one concerning the minimal threshold and necessity or usefulness of the criteria for that. So, coming to the first question, Ambassador Leto mentioned the separate opinion of Professor Zima. It's a famous dictum, and his opinion was indeed in favor of the application of the military reprisals. But we should bear in mind that this issue indeed have been discussed at different levels. And for instance, the International Law Commission discussing the possibility or lawfulness of military reprisals came to the conclusion that in 2001 that they are not lawful. So they have, we can say, changed their mind, because in their writings of 1980 we can find this discussion on the lawfulness, but finally in 2001 they ended up in negative. Next issue is, well, they are also prohibited in the Friendly Relations Declaration, and at least two judgments of the ICJ, the Nicaragua case and the Corfu Channel case, also prove the unlawfulness of military reprisals. And coming to the question concerning the minimal threshold, three very brief points here. Firstly, we should not forget that it is inherent for public international law, fortunately, unfortunately, but international law is very indeterminate in comparison to the national rules. Here, indeed, discussing the applicability of Article 2.4 of the UN Charter, we indeed require more. We read into this provision some details, and we require some details. They are necessary for us. But indeed, even if we are speaking about kinetic attacks, the international law here, the interpretation is not as clear to provide us with the answers. My second issue is, well, we have discussed whether a list of criteria might be useful. I think here that the crucial issue is a question of a non-exhaustive character of this list, which was proposed by a number of states and is still supported as an approach. As a lawyer, I would say that, well, if it is non-exhaustive, we have here, as lawyers, always problems, and it sounds not very legal. If it is too open, it brings indeed so much legal uncertainty to legally uncertain issues that it is probably too much for the legal discourse. It might be helpful for the political one. And my very last and third point here is that, well, we know that in the talent manual we can find a list of criteria for the qualification of use of force under Article 2.4. But we should be indeed very careful here, as even the experts working in the NATO, under the auspices of NATO here, had expressed different opinions with respect of how this list of proposed criteria should be applied and which results it might have. So, for instance, should we take as an example one of the earlier cyber incidents which happened with respect of Estonia. The head of the group, Michael Schmidt, even would have applied this list of criteria and qualified the incident as falling not even under Article 2.4, but under Article 51 of the UN Charter. So here, the list of criteria, well, might be helpful for some purposes, but it does not, legally speaking, provide us with rather clear answers and clear vision of how and where the threshold between the use of force on the one hand and interference in domestic affairs, when the breach of sovereignty should lay. Thank you very much.
Thank you, Professor Rusinova. And before I wrap up the panel, I just want to go back one last time to Ambassador Leto to ask if you have any final thoughts on any of the questions that were put forward for discussion. Just want to make sure that I give you the chance to share any final thoughts.
Thank you very much. I believe there has been quite a lot of agreement in the panel, not really views that I would object to. Obviously, we can, and I have no idea, no intention of repeating what I have said. I hope it has been understood correctly. I could come back to one of the earlier questions regarding non-state actors very, very briefly. It was already commented by Mr. Young. What I could add is that there has been an ongoing debate on whether non-state actors could launch an armed attack and how the state that is the victim of such an attack may respond to it. And this is, as we know, it is a debate that has been conducted regarding armed force as such. I'm not aware of a similar debate regarding Article 2, paragraph 4. And it seems to me that it continues to be generally understood that Article 2, paragraph 4 only addresses states in their international relations, as it says. Thank you very much.
Thank you. Thank you so much also for sharing your thoughts on this point of non-state actors, which I'm sure will come back over the course of the day in multiple occasions. So all is left to do is please ask you to join me in a round of applause for our speakers today for sharing with us their expertise. And just a couple of logistical points for those of you that are here with us in New York. There is now a coffee break until 12. We'll start right on time. And if I can please ask you, either on your way to the coffee, which is going to be served here by the Vienna Cafe, or on your way back to the room, if you could please come to the front and sign the attendance sheet so that we can see who was who participated in person. That would help us in tracking all of our metrics. So thank you so much once again, and please do enjoy the coffee break, and I'll see you at 12.